Few days ago, President Buhari, while addressing the NBA conference in Abuja, said the rule of law must be subject to national security. But that statement did not sit well with some of these legal minds. And as the NBA conference continues on Wednesday, where the rule of law and human rights took center stage, some of the aggrieved senior lawyers, like Michael Zokame, threw a question to the panelists.
Okay, fine. The question I want to ask is, when there is a deliberate misinterpretation of the judgment of the Supreme Court in Asari Dokubo, which merely talked about human rights, when as a matter of fact, all the courts of the land, from High Court, Court of Appeal to the Supreme Court, had refused bail on the ground that he was involved in insurgency. When such a misinterpretation is given to the president of a country by those who are supposed to protect the interest of the country, particularly the office of the Attorney General, is that not the more reason why we should quickly separate the office of the Attorney General from the office of the Minister of Justice?
After the question, Falana was quick to present his standpoint and was supported by his co-panelists.
The point made by the president has long been captured in the Latin maxim, Salus Populis Suprema Lex. The law of the society will take precedence over individual liberty. Where we can depart from the president is the attempt, whoever wrote the speech, to use the case of Dokubo Asari versus Federal Republic of Nigeria to justify disobedience to court order. In that case, Justice Tanko made the point. There's only when you have peace that you can talk of your individual liberty. But if the country is in peace, you can't talk of human rights. And nobody can dispute that. But who defines national security? Is the court. Section 45 of the Constitution has provided that many of those rights in Chapter 4 can be suspended in the interest of defense. Even when you have a case involving children in court, you can send everybody out in the interest of the child. You can't talk of public hearing. So the law is very clear on this.
Okay, because it's not a choice between respect for the rule of law and the promotion of national security. And the point I was making is that the concept of national security, broadly defined, has to have the rule of law as part and parcel of national security. Because if you talk about the physical security of the state or the security of a particular government, then you might have that secured, but the insecurity of the people. For full security of the people, which is ultimately national security, rule of law has to be respected. But I agree with Falana is that, it's not that by all means, even if the state collapses, we must have rule of law. No.
Christy Brimelo is a London-based human rights activist and lawyer. She appears to have been following cases of human rights abuses in Nigeria.
Is such that Nigeria, the government and the president, has promised under international conventions that it will be bound by international law. If there is a state of emergency, that must go to the National Assembly, and that looks at your constitution. What cannot be done is say that national security or public interest are such that there can be a compromise on individual rights. That is not in keeping with international law or domestic law, and also it is confused because it is not recognizing that in fact that those rights are there in order to safeguard the functioning of a proper judicial system within Nigeria.
Having spent the last few days deliberating on key judicial issues, these interactions marks the climax of the 2018 conference, which will end on Thursday. Emmanuel Bagudu, PTV News, Abuja.